Hello and welcome to this video about negligence, in particular a duty of care. So the focus of this video, which is going to be the first of three, is a duty of care, but there will be a second video on breach and a third video on causation, defences and damages, and together they will form the whole of the law of negligence. And in each video I'm going to consider how to apply the law to an AQA exam scenario. Negligence is a tort which comes from the French for wrong. It's part of the civil law and it's concerned with carelessness. So people involved in accidents probably don't intend to cause harm, but they are careless when they cause the accident. And in criminal law, we've seen that the highest form of mens rea is intention and then recklessness. And underneath this sits negligence. It's not as bad as to be criminal conduct, but can result in you owing someone compensation. So in our everyday lives, people are careless and they cause physical injury and or damage to property. So for example, in a car accident, people may have been injured and there may be physical damage to the car or other vehicles, and this can be compensated for. In addition, if someone loses money as a result of either damage to property or personal injury, for example, by not being able to go to work because of their injuries, then this is called consequential economic loss and can also be claimed in a negligence claim. And it's important to note that public policy is really important in the law of negligence, and primarily the concern in civil law is that the floodgates of litigation are not opened. We do not want the courts overwhelmed with a very large number of cases. It's also about loss allocation, making sure that we allocate losses to the right people by making use of insurance and contracts between parties. So civil law imposes limitations on liability, taking into account public policy issues and also the practical impact of imposing duties on people. So we are all negligent or careless every day. We bump into things, we drop things, we drive too fast, we drink too much, we don't look where we're going. But there's only a problem where, because of our negligence, someone to whom we are legally obliged to act carefully suffers damage. So this is the legal concept of a duty of care. And we are going to consider the circumstances in which one party is liable to another in negligence. Now, sometimes this will be really clear, and these are our existing duty situations. So for example, it's pretty clear that road users owe other road users a duty of care. But there are also going to be cases where there are new areas of liability and the law is extended to cover a situation that it didn't previously. So the overall structure for negligence is A, B, C, D, D. And all of these elements have to be present. So I can be a driver of a car and I owe a duty to other people, including my passenger. I can even breach that duty by not paying attention and having an accident. But if I don't cause damage to anyone, then there will be no liability in negligence. So it's important to note that in this video, we're just dealing with a duty of care, but you will also have to go on and consider the other aspects depending on what sort of question you're answering. Now, the whole concept of negligence links to fault and also to morality, which are both nature of law topics that you need to consider in paper 2 for AQA. So you'll need to be aware of that and come back to it. So let's just have a recap of the law on a duty of care. It all started with Donahue and Stevenson. And so we can see that the law of negligence has developed through common law. There's no such thing as the Negligence Act in itself that sets out all the elements of negligence. They come from the common law, from judges who have made laws starting with Donahue and Stevenson. And this was a snail in the ginger beer case, and it introduced the neighbour test. And this comes from the Bible and love thy neighbour and the parable of the Good Samaritan, and it means that you owe a duty to people who are closely and directly affected by your actions. And in this case, it was the end consumer of a product that had been manufactured and had the snail in. So this was the case until the 90s, when Caparo and Dickman replaced the neighbour test with the three-part test. And I remember it with the mnemonic Fantas Perfect, Fantas Just Right, which stands for foreseeability, proximity, and fair, just, and reasonable. And those are the three parts of the three-part test. And these are still really important today because they confirm to us that the elements such as fair, just, and reasonable are still important in new cases, because this is the test that will still be used, even though Robinson, which we're going to come on to, is now the leading case. So Caparo is still relevant for totally new situations, but you will not be asked about a totally new situation in the exam. And it's important to note that in psychiatric harm and negligent misstatement, it is proximity that changes. So it's good to have an understanding of how these elements fit together and where they came from, which is Caparo. They're also important in the theory of tort law, where fair, just, and reasonable does not actually mean at all fair, just, or reasonable. It's nothing to do with it. It's all to do with public policy and policy considerations surrounding when you might impose a duty on public authorities, for example, the police. And you will have come across the case of Hill, where the mother of the last victim of the Yorkshire Ripper sued the police for failing to arrest the Yorkshire Ripper, and liability was denied because the courts felt it would open the floodgates of litigation. So that was a decision based purely on policy reasons. So let's have a look at Robinson, which is the leading case for duty of care. In this case, the police were arresting a suspected drug dealer in the town centre, and as part of the arrest there was a violent struggle which resulted in an older woman who was out shopping getting injured, and she sued the police, and the police were held to be liable as this was a positive action as opposed to the omission in Hill, and it resulted in some reasonably foreseeable harm to the woman. And what Robinson also tells us more widely is that new cases will be developed incrementally and by analogy with previous cases, which simply means that there'll be new cases will come along bit by bit and by comparing them and their facts to those of previous cases. So what Robinson tells us is that you need to first of all look to see if there is a precedent. And if there's already a case that holds that there's a duty of care, which is similar to the case under current consideration, then you use that precedent and you don't need to worry about the three-part test from Caparo. All you need to worry about is proving that there was foreseeability of some harm. And just to note here that proximity will be dealt with in the precedent that you choose, and we'll see how that works in a moment. So when you're choosing a precedent, which is the first thing you need to do in a negligence scenario, often in the exam Nettleship and Weston is very useful. And Nettleship and Weston is authority for the fact that road users owe other road users a duty of care. And that can be expanded out into really quite wide situations, from tractor drivers to boat drivers. And so therefore it is quite useful. Donoghue and Stevenson, manufacturers owe a duty to the end users of their products. And Carmarthenshire County Council and Lewis was a case where a teacher potentially owed a duty to a child, so can be used in cases where people are in caring relationships. For novel or new situations, as I said, you'd use the Caparo three-part test, but they are not going to have a new situation in an exam scenario. However, this might be relevant when you're looking at theory of tort law. So really, you just need to pick a precedent that you think would be the most relevant, and then identify it and why you think it's relevant. Then you need to look at the test for foreseeability. And this is where the court asks if some harm to a person in the claimant's position is reasonably foreseeable as a result of the Defendant's Act. So this is an objective test. It's not what the defendant thought would happen. It's what is reasonably foreseeable. And in Kent and Griffiths, it was reasonably foreseeable that a sick person waiting for an ambulance could be further injured by the ambulance taking too long to arrive. And the ambulance seems to have driven a little bit over our writing there, but hopefully you can see that it would be reasonably foreseeable for someone to suffer some further harm if an ambulance takes too long to arrive. So questions in the AQA Paper 2 exam on negligence can be multiple choice. There can be a 5-mark question which would focus in on a particular aspect such as duty, breach, causation, defences or damages on its own, any of those A, B, C, D, D. A 10-mark question which could need you to do the whole of negligence, and part of a question 10 or 11, the longer 30-mark scenarios, could certainly include negligence. So this is a scenario question from the AQA exam in 2022, and you could pause and have a quick look at that and note that it asks you about the rules on negligence and contributory negligence, which we'll see in the later video is a defence, and you're advising Jake of his rights, so his rights in law, in the law of negligence, and remedies. What might he be awarded in terms of damages against Candy, who is the defendant. So my tips for scenario questions are to read the question and the scenario twice. If it's in a longer scenario, to make a plan to ensure you don't miss things out. Make sure that you identify the negligent act or omission in your plan, because that is what you are always going to be returning to. And if you are short of time, try and state and apply the law in one to save time. So these are the elements that you need to think about. Who's the claimant? Note the spelling is A-N-T. Who's the defendant? Again, A-N-T. What is the negligent act or omission, and what damage has been caused to the claimant? So here the claimant is Jake, the defendant is Candy. The negligent act was driving whilst distracted by her mobile phone, and the damage suffered by Jake was a broken leg. So in this scenario, you would start with an introduction, identifying the main issue in the scenario. Jake may have a claim against Candy in negligence in relation to Candy driving whilst distracted by her mobile phone. You can't conclude right at the start that Candy has been negligent. You need to go through all of the elements first, so don't conclude at the start. Then you need to deal with Robinson. Robinson confirms it's not necessary to apply the 3-part test from Caparo for established duty situations, only where the situation is new. And Robinson says you look for an existing precedent and apply the foreseeability test. So that's what we're going to do. In relation to a precedent, here a similar case might be Nettleship and Weston, where road users owe other road users a duty of care. Here Candy may owe a duty to Jake as he was a road user as he was riding his bike. So you're saying which precedent you're choosing and why you are choosing it. And then you need to do the test for foreseeability, because Robinson says we still need to do that. So as to foreseeability, some harm is reasonably foreseeable to someone in Jake's position, as driving whilst distracted by a mobile phone may cause some harm to other road users, as you may crash. And note here that we are applying this as an objective test. It's not that Candy should have foreseen or Jake should have foreseen or anything like that. It's whether it's reasonably foreseeable that some harm could come to someone in Jake's position, and the authority is Kent and Griffiths. And then you just need to say that proximity will have been decided in the original precedent of Nettleship. So you don't need to decide proximity here, because in Nettleship and Weston they've already decided that there is a proximate relationship in time, space, or relationship in that case, so you don't need to do it again for Jake and Candy. Then you need to conclude, a mini conclusion at the end of duty. Candy owes Jake a duty of care, but note that you will still need to go on, if it's a longer scenario, as this one is, a 10-mark question, to consider breach, causation, defences and damages. And that is what we will be doing in the later videos. So I hope that's been a helpful explanation of duty of care. Thanks very much.